In studio, I have an advocate who has a clear understanding of the steps that will be followed and what we can expect in this electoral disputes resolution process that we are to get into, and that is Muthomi Thiankolu. Thank you so much for making time for us today. And you actually have a book there, a benchmark or book that you will be referring to a lot, and you were part of actually putting that together, and it informs what will be followed in terms of the rules, and that is on the electoral disputes. First of all, just explain to us what will be happening today. People might expect, in layman's terms, of course, the filing of the petition. People might expect a long procedure. What can we anticipate?
Many thanks for inviting me, Mark. What will basically be happening is a NESA team, and there is a tendency to focus on the NESA team. The truth is that any other person, including you and I, every citizen has a right, according to our laws, to approach the courts to complain about an election. So I would like to say, whether it is NASA or whoever it is, the procedure is basically you prepare a document through your lawyers called an election petition. And there is nothing magical about this document. It simply says who you are, your right to challenge the election. Basically, if you are a registered voter, you have that right. And then you would say, my complaint is as follows. In fact, the typical election petition reads that the election of so-and-so, perhaps the election petition of Mr. Mark Masai, is as follows. Number one, the election was held on X date, in this case, 8th of August 2017, that the following people were the candidate. In this case, you would have to state, according to the rules, who are the candidates in that election. Then you're required to say the results of the election as declared by the chair of the Electoral and Boundaries Commission. Once you state that, then the next paragraph you say, what is your grievance? And typically the grievance would revolve around the provisions of Article 81 and 86 of our Constitution, as read together with Article 38. And in summary, these articles say, lay out the basic, irreducible minimum standards that elections in this country must meet. One of them is that the election must be free, it must be fair, it must be transparent. But more importantly, the Constitution says in both, actually in all the three articles, that the election has to be conducted in accordance with a system that is accurate, that is correct, that is verifiable. So that then when you're complaining in an election petition, what you would be basically telling the courts is that this election did not meet the minimum basic thresholds set out in our Constitution, which says ours is a democratic system of government in which the mandate to form government, and by this we mean all levels of government actually, because all the three arms of government exercise delegated power.
Right.
That is to say, the ultimate power lies with the collectivity of all the citizens in this country. So basically, you'll be saying, I am complaining because this election did not meet any one or more of the following thresholds set out in the articles I pointed out to you.
Okay.
The next paragraph is you would be expected to give particulars, which would be alluding to the evidence, because in our system of law, it is not enough for you to complain and allege, all manner of things. It is perhaps more important, even as you say, the Constitution didn't, or rather the election did not meet the constitutional threshold.
Yes, and the team, the NASA team, just to interject there, the NASA team says it is putting together a watertight case.
Yes.
And that is, of course, including the evidence. Is this the point, at the point of filing the petition, is that the last time they would be able to bring in any form of evidence on their particular case, or can they come and support their case with more later?
You're required at the time of filing your election petition to file evidence that will support the allegations made in that petition, according to the rules, that evidence will usually be in the form of affidavits. And an affidavit is just a sworn statement where you state at the oath that I am so-and-so. And that evidence itself must meet certain thresholds. Evidence cannot just be mere allegations. If I said, for instance, in my petition, in the press, the issue has been around unverified results, I would expect whoever is complaining about that to say that the IBC declared unverified results. These are the results they declared, but my evidence as to the actual results is this. And therefore, as you can see from this evidence, it would presumably be in the format of a document or an affidavit, as I said, and you would be saying, these are the actual results. So perhaps someone would be saying we were required to be allowed to verify the results at various polling stations, and we were not. And therefore, the election did not meet the constitutional threshold. It is then expected your evidence, and just by way of example, would say, Mr. Mark Masai was my chief agent, say, in Kasipul, Kabondo, and next year, too, is the appointment letter showing he was a duly appointed agent. And at page days of my petition is an affidavit by Mark saying that he was denied the opportunity to actually verify the results that were being transmitted and declared at the various constituency tallying centers or polling stations.
Right.
So basically, your petition must have the petition itself and evidence in support of it, and that evidence would be in the nature of witness affidavits and any documents that those witnesses would be relying upon to support the allegations. Something that a lot of people don't know, while the evidence usually goes by way of affidavits, there is room for actually oral testimony in the typical traditional way you know court proceedings to go. That is to say that a witness could actually be called, be asked questions by the lawyers of all parties, be asked questions by the court itself, and based on the impressions the court forms, it could believe or disbelieve that witness. Of course, for presidential election petitions, the scope for going for oral testimony is very narrow, perhaps almost non-existent, because of the time constraints that the court must hear and determine the petition within 14 days. And therefore, most of the evidence would to be by way of documentary and affidavit evidence.
All right, and I might interrupt the conversation just to cross over to Kennedy Moredi as and when he's ready, but he's not at the moment. But back to that question of whether they can, you said it's not just affidavits in form of evidence, sworn affidavits, yes. Or you can also have oral testimonies. But if later on, as the case continues, something else comes up that would support their case, can they submit this in court? Or is today's deadline of submitting the petition the last opportunity?
There are two answers to that question. One is the strictly legal answer, and the other is the pragmatic answer.
Yes.
The legal answer is yes. The rules permit you subject to getting leave from the court to adduce additional evidence, additional documents, or whatever additional material you think might support your case. And if you recall, in 2013, actually CORD, as it was then called, attempting to bring a further affidavit, 800 pages of it, and they were citing that rule that permits the court to take additional evidence. Now, the problem is usually one of practicality. The court has 14 days
yes.
To sift through all those documents, usually running into thousands, sometimes tens of thousands of pages, to hear oral and written submissions from lawyers. And here you are, attempting perhaps after the fact to bring additional evidence. So it's a catch-22, because on one side the court would want to hear all the evidence that is relevant, yet the court is tied on time. So there are two answers. My advice is I wouldn't advise anyone to hope, to leave gaps in their case and hope that they will get an opportunity to fill up through that particular route, because it's a very constricted, very narrow path, and the court can properly, exercising its mandate and discretion, actually refuse to accept that evidence.
Right. And to this particular case, it's not to address the pros and cons of this case, but you can expect evidence to the Form 34As or Form 34Bs and the disparities that they say they had seen, and as well as evidence to the hacking claims that they've brought up, right?
Yes. The more interesting one perhaps would be the hacking claims. But there is something perhaps all your viewers need to understand, because there is a particular problem unique to election petitions about evidence. Usually because of the candidates being dispersed and their agents being dispersed, what usually happens is your adversary, the Electoral Commission, would have more information than you do.
Right.
And the natural human tendency in an adversarial system like ours is that they would try as much as possible, even if not officially on the record, to exploit that informational asymmetry, so that the time actually to win an election petition is not after the declaration of results. It is to have your agents in every polling station, in every constituency tallying center, and I hope that links with previous discussions about parallel tallying and whatnot.
Right.
So that if you don't have forms from your agents, it is more likely than not that the commission will be intransigent and will try to play games and will not cooperate usually until the very last minute, when you wouldn't have the time anyway.
But wouldn't that be seen to sabotage your cause and case, and by extension then show that there's an attempt to hide?
Yes, if you're speaking holistically, but the nature of our legal system is that the person who alleges is the one who must prove. I would imagine the petitioner would be the one alleging that the election did not meet this constitutional or legal threshold,
right,
and therefore they would be expected. And to be fair to the Electoral Commission, even with the issue of the informational asymmetry, the whole thing really boils down to diligence and logistic organization. So that if you hadn't done your homework well, so to speak, then you're going to encounter so many difficulties proving your case. The rules require, once this petition is filed, the Electoral Commission must submit all the documents. That is, in this case, would be Form 34As and Form 34Bs, and the one Form 34C to the court. And the court is at liberty to actually examine those documents, which is another aspect a lot of people don't know. While largely our legal system is adversarial in character, election petition proceedings are partly inquisitorial in character.
Meaning what exactly?
That is to say, by adversarial system, we mean the judge does not go to conduct inquiries into your allegations. And if I may give you an extreme and mundane example, it simply means if the judge was passing by and saw me punch you on the street, and you appeared with your case before the judge, it is not enough for you to assume that since the judge saw me punch you, you have proved your case. The judge is supposed to have been blind. So in an adversarial system, the judge doesn't know anything, doesn't see anything, doesn't hear anything except that which is presented by the parties, and the whole idea is that the judge should merely be an umpire. Of course, that's a bit too academic,
yes,
because judges live in the real world and they interact with all the usual things every human being interacts with.
But in this case, they'll be examining a lot of...
So I'm saying largely our legal system is adversarial, which means the judge does not conduct any independent inquiry to know where the truth lies. But there is a qualification to that. When it comes to election petition proceedings, the court actually has a leeway to be inquisitory in nature, which is to say the court can conduct its own independent evaluation, its own independent inquiries, and perhaps reach its own independent conclusions, notwithstanding the evidence the various parties put before it. And it is in that context, that is at least the theoretical basis why the rules require, once an election petition is filed, that the Electoral Commission should submit the forms before the court.
Yes.
And it is perfectly in order for the court to examine those forms and even pick out issues that the complainants or the respondents may not actually have picked.
Yeah, but this, given the timing, and some people have said it needs to be more than 14 days to 30 days, then they don't quite have a lot of time to even examine, and one would assume from a layman's standpoint,
Yes.
to examine and interrogate probably the evidence or the numbers that are put forward by the IBC, the respondent. Yes, so that kind of, would you say that really restricts?
It's true there are serious capacity constraints occasioned by the constitutional decree that the matter must be heard and determined within 14 days. But it is also true, which a lot of people don't know, that our judges have a lot of administrative support in the background,
yes,
which
yes.
you will not see in court. At the Supreme Court, I would imagine every judge, for instance, as a research assistant, maybe 2 or more. I know judges have, within the judiciary, this huge organization they call the Judiciary Committee on Elections, whose role is to facilitate them to discharge their constitutional mandate. So, yes, there is constraint of time on paper, but there is also a lot of support from the background,
right,
which should enable the judges to...
And what changes have been since 2013 and now? Because you heard, as of course, NASA was making the announcement that they'll be going to court, that they're giving the Supreme Court another chance. What infrastructural changes would you say would go to support the notion that, or the belief that they are capacitated, they have the capacity to address this particular dispute within the time frame that they are given?
I am aware through largely professional engagements,
right,
that the judiciary has made huge investments in preparing for electoral dispute resolution. One of them is a book I think I had shown you,
yes,
which is was released just 2 or 3 weeks ago, on that to be precise. And this book, as you can see, is styled Judiciary Bench Book on Electoral Dispute Resolution.
yeah.
So
in fact, let me just hold it up to the camera.
Yes.
Because you say this is available to,
yes.
To the public online.
Yes, that book is available to the public online. It is available to every judge and magistrate. And basically the purpose of this book was to prepare and equip every judge and judicial officer to quickly have a reference point with regard to any question that could possibly, at least by the imagination of the team that was preparing it, the questions that could possibly arise, so that the judge has quick answers or pointers to where he can get the quick answers to that legal issue or that legal question. I am aware, besides the book,
yes,
that there has been a lot of training and capacity building within the judiciary to deal with this type of disputes. I'm aware there have been internal conversations,
yes,
within the judiciary itself about the merits and demerits of the post-2013 electoral dispute resolution. And I think there have been debates out there about the 2013 presidential election petition in particular.
yes.
I'm aware there have been conversations about some of the controversies and complaints arising from the manner in which the judiciary and the Supreme Court in particular handled it. What I don't know is how that will translate into the decision-making this time round.
For this time
Yes.
round. And we'll get more of your responses and interpretation of the legal issues that are at hand after we take this short break, Bwana Muthomi. And as you've heard, this particular book is available online for you, and you'll be able to get all the answers. I guess you could call it the Bible in terms of electoral disputes here in
the Judiciary website.
Yes, on the Judiciary website, you can get it for yourself and refer to that. We'll continue with the conversation here after this short break. Stay with us for this particular petition. But let's continue with the conversation with Muthomi, and he has a good understanding of petitions. He's been part of petitions himself. He'll tell us a bit more about that later. But what are some of the things that we can compare and contrast from 2013 and 2017? Of course, there's some peculiar differences, but what are the parallels that we can put here?
Now, of course, there is a parallel in the parties involved. NASA is largely a mutation of code, just a change of name. The Supreme Court has had changes in membership. I think there are 3 members who were not in the court that time. But perhaps what I think we ought to be asking, there is always a lot of debate, whether in political or academic circles, about how the 2013 presidential election was handled. And for me, what I always find curious is there is too much focus on the perceived feelings of the Supreme Court. And no one talks much about how the case itself, how the complainants presented their case, which I hope will not see a parallel now that we are discussing this time. My own analysis of how COD, as it was then called in 2013, is they perhaps got the approach completely wrong, which is they took a generic story, BVR kits, procurement, technology, and whatnot. And my own view is that they spent a lot of the little airtime they had describing the process in its generality and the shadows of doubt that they claimed that arose as a result of the feelings of the process. And it is only after the event, when the horse had already bolted, that the court attempted to bring the evidence, which was the 800-page affidavit. My own view is perhaps if they had flipped the sequence, if they had focused their energies more on the material in that 800-page affidavit and made these other stories about the procurement process, the failure of technology, the BVR kits and whatnot, maybe they would have prevailed. Actually, they would have forced even an unwilling court to, because the court could not ignore that evidence. But what did they do? Most of the time and energy and resources were committed to describing the general feelings of the process without going into the particular question of how those feelings impacted on either, because our law is that an election petition can only succeed on 2 grounds. One, you're able to show that it has not been conducted in accordance with the principles laid in the Constitution, which some lawyers and judges call substantial compliance test. Or you're able to show that the feelings of the electoral management body, whether trivial or substantial, have affected the outcome. That is to say that either the outcome would have been different or the margin would have been so reduced as to cast a serious doubt whether the declaration was actually an expression of the will of the voters. So my view is perhaps we ought to have a critical discussion even as we discuss our own perceived feelings of the court, that perhaps the court will only give you as good a judgment as your approach in prosecuting your cases.
Well, and the team says definitely putting forward a strong case, and we will see that as soon as that petition is filed. Well, one of the other things that, and this is definitely, as we are talking about this and discussing this, is not on any political side. This is all on the legal, from a legal standpoint, and definitely looking at interrogating the strength of the issues that were presented in 2013 and what we can anticipate for this particular petition that will be filed today. The issue of the hacking claims and the evidence that will be produced in court with this petition, some argument from a layman's perspective is for you to have discovered hacking, you probably did hack the system. So would it be, would you be in a catch-22 or already put yourself in a checkmate situation where you are proving that there's some hacking that happened, but you as well did the same?
Because you'll be saying I'm complicit to the very evil I'm complaining about. Although legally, strictly legally speaking, that shouldn't be an issue, because what should matter is the relevance of the evidence as opposed to the methods by which it was obtained. At least that's what the law of this country is, that while courts are mindful of ensuring they don't entertain evidence obtained through improper or illicit methods, at the end of the day, really the question is whether the evidence is relevant to the issues. But still on the hacking, for me, the difficulty is not even that for you to prove that allegation, you would have to implicate yourself in doing the same evil. It is the problem I told you earlier on of the information asymmetry. The server is owned by the IEBC. It is in the custody of the IEBC. It is operated by the IEBC.
Yes.
You have no password to access it. So the immediate problem you encounter with an allegation of that type is how do you prove it? Since we said our system is adversarial, short of the court bending over and perhaps to the extent of appearing maybe biased, how will the court be able to assist you on that allegation? The second problem with that allegation is that even if it could be proved, it may not necessarily amount to much.
Yes.
Because under our law, the results are those declared at the polling station.
Okay.
So whether the system was hacked or not, even if you can prove that the system was hacked, that without more doesn't take you anywhere. What you need to show is that at a polling station called, in my place, Kibulene Secondary School, my agent Muthomi was there, and the result that was announced as per the Form 34A is this one. However, when you go to the server or whatever, or the one that was transmitted, it's a completely different result.
Right.
Anything short of that, for me, the allegation of hacking might see the same fate as the 2013 allegations around procurement of BVR kits and failure of technology. The allegations that fine, you prove them and they prove some legal infringement, but they don't get you what you're seeking from the court.
My goodness, you're a lecturer.
Yes.
So, and this is why they say the law is an ass. And I'm not cussing. This is from a legal standpoint.
Yes.
That is why they say the law is an ass.
Yes, but while the law is an ass, perhaps sometimes it's we lawyers and judges who are big asses, because our constitution says that part of the principles guiding administration of justice is that justice must be administered without undue regard to technicalities of procedure. The elephant in the room, of course, is what is undue regard and what is due regard, because procedure is supposed to facilitate an orderly dispensation of justice. So I don't know, but my own view is that is an allegation which, even if we were to assume in favor of the complainant without more, it wouldn't win them the case.
All right, and this is something we'll watch as it unfolds. We'll look at something that you said. It's not only NASA that will be filing a petition. There's perhaps a group that will be making its way to the Supreme Court registry. A coalition of civil society organizations in Kenya under the umbrella of Kura Yangu Sauti Yangu have called for an audit of the entire IEBC election results and the whole process leading to the announcement of the results. The group says that the information received from over 500 people they tasked to monitor the elections in all constituencies paint a different picture from what the IEBC announced.
Registered voters in 45 counties varied from what was announced on August the 11th, and it bears repeating that register already carries more than 1 million dead voters. So we should always remain alive to the fact that even after the cleanup exercise, the register did retain those that are referred to as dead voters. Hundreds of thousands of shared identity cards and illegitimate entries, as well as errors.
We found massive errors between the information from Forms 34A and B and the results calculations posted by the IEBC website.
At face value, they suggest a full audit of the results of the IEBC and their reconciliation with the authentic documents from the polling station. The amount of missing data a full week after the elections calls into question whether the declaration of the results could be made legitimately. We shall be involved in whatever petition that shall be before the Supreme Court. And I think it is of extreme importance, not only to the Kenyan people, but also to the judiciary itself and all other stakeholders, to see the pronouncements that the Supreme Court will have to make on some of these issues.
A representation there of the civil society groups under the Kura Yangu Sauti Yangu umbrella. And Bwana Muthomi, this is definitely one of the groups that will be filing a petition. Is there a limit to this? Because the focus is NASA and the petition they will be filing, but we can anticipate as well other players in this.
There is no limit. As I said earlier on, perhaps we are focusing on NASA because of our country's obsession with, the tribal formations reflected in the two leading political coalitions. But I would like to begin perhaps with the last person who spoke about what they should expect. Earlier on, I told you what I believe were were the feelings of the complainants in 2013. And maybe it's time I tell you what I think were the feelings of the Supreme Court. Mm-hmm. You see, our Constitution is transformative in character. That is to say, when Kenyans went into that referendum, they enacted this Constitution, the agenda being to bring large-scale socio-economic and political change across all spheres of governance in Kenya. And what many people, especially those like me who transcend both legal practice and academia, were hoping to get from the Supreme Court. And I think that's where most of the criticism and disappointments have laid, is I told you earlier on, the Constitution requires that at Article 81 and 86, the election to be free, fair, transparent, correct, verifiable, accurate, and it also requires the IEBC to put in place mechanisms to avoid electoral malpractice and fraud. Mm-hmm. What a reader of the judgment from the apex court in the land would have wished to see is an explanation of what that new constitutional threshold meant. What did it mean? Was it just words we were throwing into the Constitution? And since the agenda of the Constitution was transformation, yes, how did the Constitution, what transformation did the Constitution envision even from the judiciary itself in handling election petitions that is so fundamentally different from the approach in the previous electoral cycles? So for me, I think if the Supreme Court is to acquit itself properly, irrespective of which way it decides that dispute, it must tell us what is the transformation, what is the promise given by Articles 81 and 86. What do those words I just said mean, and when applied in a particular evidential context? For instance, in 2013, the context was filling of BVR kits, shenanigans around procurement. How do you reconcile those things, assuming they were approved, with a very lofty ideal of the Constitution about an election that is free, fair, that has sufficient mechanisms to avoid fraud and irregularity. There seems to have been a disjointed approach to that question, and I think that's why a lot of people found it easy to punch holes. But while on the matter, the IEBC also, and I don't know, because this seems to be a legacy even after we kick out several commissioners and replace them with others, my own observation is that perhaps all these controversies will never arise if the IEBC approached its mandate with this transformative vision of the Constitution. What you realize is in the last 1 year or so, there have been countless suits against the IEBC to force it to do that which they are required by the law to do anyway. And you would have expected that once you're sued to actually do that which you're already obliged to do, maybe the thing you would do is you'd go to court and say, sorry, judge, we haven't complied because of these constraints, give us this time, and then we'll comply. But what has IEBC done? In all those cases, without exception, IEBC has taken the traditional legalistic adversarial approach, which is insist you're right, fight it if possible all the way to the Supreme Court. For instance, the register, I just saw something about the register there. The IEBC was obliged by law to publish this register online. They didn't do so. Some of us even kept telling them free without even charge. Why don't you publish this? It will only create unnecessary tension and suspicion and lead to unnecessary disputes. They said they would do it. When they eventually did, what they published is actually not the register, but extracts of the register. So I don't know where you voted, whether you saw any register because we were using the devices. But as we speak, the IEBC has not complied. Now, that's a legal obligation. Why would you not comply with the legal obligation? If you go to this procurement, about the ballot papers and whatnot, the IEBC appeared, and I'm not saying that was the agenda, appeared hell-bent on procuring it at a particular way by whatever means necessary. Yes. Now, you see,
well, they gave the time constraint issue.
Yes, but if you check the history, for me, the problem is not actually whether they were right or wrong, because they are human. We are all right and wrong sometimes. My question is, if your approach to your mandate is always one that invites question marks, that invites controversy, especially when that is avoidable, if your approach, even when you're challenged, is to fight, it is not every battle you must fight.
Yes.
Some things you just perhaps say, sorry guys, actually, although we've not done this, it is not because we are up to any mischief. These are the difficulties we have, and we really hope you will understand. So I think IEBC has really failed the country, especially in their confrontational approach. Each time you challenge the IEBC on anything, they take it that you don't mean well for the commission, and therefore we must fight you, even all the way to the Supreme Court.
Right. And what you've heard here from the civil society representatives is that they had at least 500 people monitoring the process, and they notified or at least identified some of the lack of procedure being followed, instances of lack of procedure being followed. This is something that you think admissible, is admissible before court?
Yes, of course it is. If you can show that, as I saw in the clip, that there are discrepancies in the number of registered voters vis-a-vis the voter turnout, if you can show that there were dead voters, although that doesn't end there, for me what you need to show is that these dead voters somehow cast a ballot. The mere fact that they are dead voters doesn't mean much, because people are dying all the time in a flux in no orderly frequency, and therefore the IEBC can never have a register that doesn't have dead voters in it, because people die even on the election day itself. Some people die hours to the election day. The real thing is, did the result that we declared reflect the people who are actually entitled to vote and who actually voted in that election?
Right.
That's the real question.
Okay. Okay, and I think we have some footage there. We'll be able to show what is happening from Embu with Enoch Sikolia, another example of another governor who is going to be sworn in, actually being sworn in, just about to happen. We have Leila Mohammed in Kajiado, and in Tharaka Nithi we'll have Kennedy Mureithi. Let's listen in for a bit and just take a quick break here. Martin Wambora there, looking quite thoughtful and reflective, perhaps, of his 9 lives, Muthomi, because this is a man who has faced a lot of opposition. And you say, because people are asking as well, we're already seeing governors being sworn in. Does this mean this is a sealed deal and there will be no petitions towards them?
No, not at all. Our legal system is based on the assumption that the delivery of public services must continue, even when there are disputes as to the legitimacy of the occupant of the office. So it is largely a public interest matter, and the policy of the law is, while Mr. Muthomi or Mr. Masai may have legitimate questions as to whether, in this case, Mr. Wambora has been validly elected, the law says that the office cannot be vacant because there are important constitutional public functions that must be discharged, and therefore there must be an occupant of that office. The compromise the law gives
So this can go on, how long can it drag on for, if the petition and the cases against it?
A maximum of 6 months. The law is he will be sworn in, and all those governors or whoever MPs, the president, they could be sworn in. Then you go on, the election petition will run its full course. If subsequently the court is persuaded that this gentleman or lady ought not to have been declared the winner in the first place, the election will be nullified, and the people of that particular county, constituency, or in the case of the presidential one, the whole country, will go back to the ballot to elect their preferred person properly. Yes. For parliamentary election petitions, and by parliamentary election petitions, I mean parliamentary and county, that is to say offices of governors, senators, MCAs, and members of the National Assembly, the constitutional time limit in Article 105 is 6 months from the date of filing the election petition. So the election court must determine that petition within 6 months. It could lag on for another 6 months if there is an appeal. And technically speaking...
Okay. Let's just listen in a bit.
I, Martin Wambora, having been elected as county governor in County Executive of Embu, do hereby confirm that I've read and understood the Leadership and Integrity Code for the state officers in the County Executive of Embu, and hereby solemnly declare and commit myself to abide by the provisions of the Code at all times.
Basi wakati gavana wetu His Excellency Martin Nyago wa Mbora anatia sahihi, kumbuka hii sherehe tumealika watu wote kote nchini Kenya. Na sisi watu wa Embu ni watu wakarimu sana, basi ningeomba tupatie wageni viti. Watu wa Embu ni wakarimu sana, tuko na wageni kutoka pembe zote za nchi yetu Kenya, tafadhali tuwapatie viti. Naomba security munisaidie, na pia watu wa Embu ni watu wako na nidhamu zaidi, na tuwapigia makofi wakiondoka kwa hizo viti.
Martin Wambora has been sworn in there as the governor of Embu. Bwana Muthomi, this is one man who knows the meaning of 9 lives, even more perhaps, but he can be one of those to expect a petition on his way.
Yes, definitely. Wambora seems to have a way of emerging out of crisis after crisis and always emerging on top. I suspect because of the narrow margin with which he won the election, it will not be too hard to speculate that in all likelihood there will be an election petition challenging his election. Yes. Perhaps what remains is for us to see whether he will have another set of 9 lives. In the last term, he was impeached twice, confirmed by the courts, but still somehow, due largely to problems in our legal system, which sometimes doesn't facilitate an expeditious determination of the dispute, he served his full term.
Right. And don't you think this then just takes any form of hope in the Kenyan for justice?
Not really. Maybe what we need is more sensitization among both the bar and the bench. It's easy. A lot of times we love to blame the judiciary for all this delayed justice, and we forget who is it makes all those unnecessary, frivolous applications, which you had asked me to expound, interlocutory applications.
Yes.
That the court must determine, and the court can't, shut its eyes to them. It is actually litigant. So we create roadblocks on the road of justice, and then when we get the result, eventually we turn around and say the judiciary is responsible for delaying justice, when it is us abusing the adversarial nature of our legal system, right, to delay justice.